Blessings, beloved. I believe the following to be true. When a judge of the circuit court, prior to an appeal hearing set before her that same day, decides to grant an adjournment of that same appeal hearing on the basis that a challenge to the constitutionality of the section, in this case 115 of the Criminal Justice Public Order Act 1994, is underway, she shows that she cannot impose greater sanctions without hearing the appeal. She also shows bias in that in the absence of hearing the appeal, she has imposed greater sanctions, disqualifying herself from hearing the appeal and breaching her oath of office at the same time. In other words, she decides not to hear the appeal, awaiting the High Court's ruling on whether the High Court judge believes that the Section 115 of the Criminal Justice Public Order Act is constitutional or not. By deciding to adjourn and not make a judgment awaiting the High Court's decision, she shows that she cannot lawfully take a position of judgment until the appeal is heard in court. In other words, until the judge presiding over the court has evidence produced, actually goes about hearing the appeal, she cannot make a ruling, she cannot take a position, she cannot show bias, because all people are equal before the law. So she cannot act in a way to impose greater sanctions, because in doing that, in motioning to impose greater sanctions, she agrees with the sanctions that are already in place. And by agreeing with the sanctions that are already in place, she shows that her position is in agreement with the prosecution's prior to even having heard the case. By deciding to adjourn and not make a judgment awaiting the High Court's decision, she shows that she cannot lawfully take a position of judgment until the appeal is heard in her court. When she then stands in agreement with the state prosecution and states that greater sanctions should be imposed, and actually carries the motion to impose greater sanctions, having failed to yet hear the case at all, she hasn't heard it, but she's imposing greater sanctions and agreeing with the prosecution. Having failed to yet hear the case at all, she hasn't heard it yet. She shows that she cannot therefore make a ruling on imposing greater sanctions as a condition of the adjournment. That's a condition of the adjournment, is the judge can't make a ruling because she hasn't heard the case. Without showing favoritism or bias, she cannot make a decision prior to hearing the case. As she already agrees by imposing greater sanctions, she already agrees that greater sanctions should be imposed without having heard the appeal. How then can she claim to act without bias when she has already agreed to greater sanctions being imposed prior to her even hearing the case? A judge must not show bias or ill intent towards a person, as all are to be held equal before the law. And in an appeal hearing, there must also be the presumption of innocence. I am amazed that this has not come to the attention of the judiciary and the bar present in court on that day. She also wishes me good luck, as though luck should or could be an ingredient in a ruling of a high court as to whether a legislation is found constitutional or not. Surely luck should not have a role in the reasonability and constitutionality of law, nor should a judge suggest such a nonsense. Blessings, beloved. Jesus is sovereign. We see more and more why this world will come to an end. Blessings, beloved. Put your faith in Jesus and you will be saved. Romans 10:9 says, if you confess with your mouth that Jesus is Lord and believe in your heart that God raised him from the dead, you will be saved. Blessings.